Hi, I'm Stephen Mathias. I'm a partner at Kocher and Company in India. I'm also the head of our Bangalore office and co-chair of our technology law practice.
And hi, I'm Ben Favaro. I'm a data protection partner at Lewis Silkin's London office. It's my first time in India, and I just wanted to say thank you, Stephen, for welcoming me here and to Coach Co. I'm very happy to be here.
So we are going to have a conversation around the interplay of privacy law in the employment space, mostly um, under Indian law and under the law in the UK. So Ben, let me start by asking you, the UK is not a part of the EU anymore. I know that the UK was GDPR compliant at one time. What's the law like now? And particularly if one's compliant with GDPR, is one compliant under UK law and vice versa?
Yeah, so as you say, the UK withdrew from the European Union recently, but as it withdrew, it put in place an identical law to the EU's data protection law, the GDPR. It's known as the UK GDPR. This law, in all material respects, was the same. There were some differences. For instance, the requirement to have an EU rep previously, where if you weren't established in the EU, you needed to appoint an EU rep. With this new law, you now needed to appoint also a UK rep if you weren't established in the UK. But apart from that, the laws were basically identical to each other. The EU then recognised that in its adequacy decision of the UK's law, basically recognising that the UK's law was essentially equivalent to the EU law. Unlike other countries that have received this adequacy decision, the UK was subject to a 4-year a window where after 4 years it would be reassessed whether that law remained adequate. So there's a lot of motivation there for policymakers not to diverge from the EU GDPR. Under the previous government, the Conservative government, there was a data protection bill that was put in play, which would have made some changes to the data protection laws. But ultimately, with the change of government, that bill has now gone, and there's no material changes on the horizon. In terms of complying with the two, at the moment, it seems that complying with the UK law will mean that you're continuing to comply with the EU law will mean that you're complying with UK law. And just one more point on this. There's not much push from employers that I see for a brand new set of laws in the UK. Employers have already spent 6 years getting on top of the EU laws and spending a lot of money training their workforces, putting in place appropriate compliance documentation. There's no real appetite to learn a brand new set of laws for the UK. So I think very much in future, the attitude of the UK government is going to be that if you are complying with the EU laws, you're going to be complying with the UK laws. And how about for India? I know that the new data protection law in India was recently passed. Is that enforced now?
No, it's not. So the law was passed in August of 2023. And in order to implement the law, the government needs to create some rules, which is delegated legislation under law. The draft of the rules have not come out yet. There was an indication that the law would get passed in the latter part of this year. There was some delay during the election period because the government's not permitted to pass any rules during election time. Mm-hmm. But the elections are over and we're still waiting for the draft rules. And once those are finalized, I expect the government would enforce the statute. Moving on to the employment space, I mean the biggest issue really in privacy, or the most basic issue, is what's the grounds for processing. Mm-hmm. So in the employment space, when an employer is dealing with personal data of employees, what are the grounds that one could use under GDPR or under the UK law?
I think the first thing to recognise is that there is no carve out for employees in the GDPR. I know that some other jurisdictions around the world might carve out employment records from their normal privacy laws. These laws usually are created for the purposes of protecting people from companies misusing data to exploit them. And in some jurisdictions, employees might be excluded from those laws. But for the GDPR, it was drafted deliberately wide. So the definition of a data subject subject or personal data is drafted wide enough to capture all processing of data, including by employers and employees. So these laws do apply. And for any employer to process any data belonging to an employee, they need a ground to apply. And there's a couple there's four main ones that could apply to most processing. There's sort of straightforward ones, like performance of a contract. So if the processing is necessary for performance of a contract, say the employment contract, then the employer's got a clear ground to process it. So for instance, an employee's bank account details, they obviously need those bank account details in order to pay the employee, which is a purpose of the contract. Other ones might be legal obligation. If there's a law that says the employer must do something with the employee's data, then that's a clear obligation there. An example of that might be the duty to provide a safe workplace. If an employer needs to process some data as a part of that, for instance, if some reasonable adjustments might need to be made or to accommodate an employee, the processing of that data is going to be covered by that ground. Two other main ones that apply. One obvious one might seem obvious is consent as a lawful basis. I know under previous data protection laws, most employment contracts in the UK would have a paragraph that would say, employee, you consent to us processing all of your personal data. Super easy. It means they can basically do anything. Those days are gone now with the GDPR. The definition of consent was changed, so it's much more difficult to rely on consent. Consent can be easily withdrawn. If you imagine having an employee and they suddenly withdraw their consent to process your personal data, the employer would be pretty stuck there. And another main one was in order for valid consent to be achieved, it takes into account the imbalance of power between the two. Does an employee really have any option when they're handed a piece of paper and said, sign this? This allows us to do whatever we want with your data. The employee doesn't really have a choice. They either sign it or they probably won't have a job. So the GDPR has come in and changed that and put a lot more personal responsibility on the employer. Consent's not the main. We actually very rarely rely on consent anymore in the employment context. But as I said, there's other lawful bases we can rely on. There's performance of a contract or legal obligation. But most things employers want to do with employee data are not going to fall within those two very narrow, strictly necessary lawful basis: performance of a contract and legal obligation. So there is a fourth legal lawful basis, which is legitimate interest. That's where the processing is necessary to pursue something that the employer wants to do. And I really love this concept of legitimate interest. There's a lot more responsibility put on the employer to make sure that what they're pursuing is basically worth it, that it's legitimate, and that the impact on the privacy of the employee isn't unreasonably impacted by that processing. So the employer really needs to conduct a bit of an assessment before they rely on this ground to see what the impact on privacy might be. And what might feed into that is, or a rule of thumb sometimes is, would the employee expect their data to be being used that way?
Right. Yeah, I mean, my understanding of EU law is that legitimate interest is probably the absolute heart of the law.
Yeah.
And really, when you look at legislation that's either consent-based or principle-based, consent doesn't work for many reasons. And one of them is that people just give consent because they have to.
They often don't know what they're consenting to. I mean, how many times have you ticked a box that says I consent to this and not read the form?
And I've done that a million times as well. Yeah, so I guess legitimate interest being principle-based, there is some obligation on the employer to use it only when there's a legitimate ground for using it.
Absolutely. And how about for India? For India's new law, what will be the lawful grounds for employers to process data under that law?
So under Indian law, there is no concept of legitimate interest. And a lot of the situations that you'd face would come under consent. But in the employment space, there is actually a carve out. So the main one is, it says for employment purposes. And what employment purposes is obviously subject to interpretation. There's another ground, which is where the employer wants to safeguard itself from loss or liability. So just, typical security type situations would be covered there. And a third one is where the employer is providing services or benefits to the employee, but requested for by the employee. So when we look at the mix of different situations that employers have come back to us and said, can we use the ground here or can we use the ground there? We do find some situations where they don't fall under either of those three. So we had one employer, for instance, who wanted to test his product on the employees. So have the employees use it. So then we said that there's no employment purpose there. Another one where the employer wanted to use videos of the employees in their marketing material. So again, we said that there's no employment purpose.
And both of those examples seem quite outside the usual employment relationship.
Yeah.
Yeah.
So there are situations like that. I think the unfortunate part also is that some of the rights, for instance, the right to receive a notice, are also not applicable where you don't need to get consent. So I think there are some lacunas there in the Indian law.
Yeah.
Yeah. Um, I guess practicing in this area, what do you see as like the key, like the main issues for privacy in the employment space that you come across, the real pain points for your clients?
Yeah, I mean, I think a key issue, I mean, these laws have been deliberately drafted to take into account changes in technology and changes of use of data into the future. As you said, they're principle-based laws. They're not prescriptive laws that say you must do X, Y, and Z in order to comply with the law. They express it more, you must achieve this, and how you do that is up to you. And so I have confidence that these laws will withstand the strength of the test of time. Obviously, there's changes in technology, and employers will want to start using employee data in a different way. I think one of the key issues, I've always thought one of the key issues for the GDPR and data protection compliance generally is transparency. So there is a general obligation to be transparent with employees and all data subjects with how you're using their data. And I think that's going to continue. The more employers want to do different things with data, more unusual things, more things that fall outside of their expectations, I think the obligations on being transparent are going to be a bit higher. But putting aside the actual legal obligation to be transparent, I do also think transparency generally just generates trust with your workforce. With any changes the employer wants to make, if you can be very transparent, very upfront, ideally maybe even consult or get employee input before changes are made, it can make a much more smoother transition. I always find if employees understand why the change is being made, why the new technology is being brought in, and transparency feeds into that, so fewer issues are likely to come up in the future. And how about for India? I know that the law is not quite in yet. What key issues do you envisage once this law becomes operational?
So I think the key issue is relates to the very structure of the law in the sense that it's largely consent based. There are a bunch of situations where you don't need consent, and there are a bunch of situations where the law is exempt. But by and large, for most of our clients and most situations of using personal data, you will need to obtain consent. And the definition of what is consent is exactly the same under GDPR. And of course, I've been told, by pretty much every lawyer in the EU that consent doesn't work, very hard to obtain, possible to withdraw it, and so on. So I think that's going to be a real challenge. There is no concept of legitimate interest under the law, no principles-based provision there. So I think that's another a big pain point. I also think that the Data Protection Authority, which is the Data Protection Board of India, um, it doesn't have the kind of supervisory or law building powers that the EDPB has to issue papers, for instance, engage in discussions with the stakeholders and all of that. And I think that's a big miss because particularly with the Indian law being a little more basic than, say, GDPR, you really want the authority to be able to build the law and to build the jurisprudence. Even the rule-making powers are with the central government and not with the Data Protection Board of India. So I think that's a big miss, and perhaps the government can amend the law. Maybe they can devolve powers to the EDPB.
Hopefully, we see that change as the law becomes operational.
Yeah, it was great chatting with you, Ben, and Look forward to collaborating with you on our respective clients as they practice in the UK and in India.
Thank you. It's been lovely to be here.